So we can pretty much draw this model out now, which is, there's no doubt to this now, it's absolutely clear. It answers all questions and resolves all resolutions. And as for any new modern legislation that they've put through, like Priti Patel with the Public Order Act, it's actually, Priti Patel doesn't really know what she's doing, I don't think. And if she does, then she's misleading people. That law the Public Order Act 2023 can apply to citizens going about their business, right? It can apply to citizens going about their business, but not people who are using right privilege or interest, which is a special law that applies. And this point in political action. So I don't know why Priti Patel made that law claiming it's going to stop political activists using a privilege, because it can't. It can stop youths or gangs or people who are just, like those Leeds riots. They didn't have a declared or official lawful right or privilege in force. They were just vandalising or randomly occurring damage, locking onto things and things like that. But it can't stop the privilege. So we're going to do the model for this now, which is, we're not going to start with the right and privilege. So I'm starting with the Criminal Damage Act 1970 or 1971, 70 or 71. So the Criminal Damage Act 1971, right, is very, very clear in its legislation. And that is that a criminal charge for an offence, a crime brought by a prosecutor and the police, right? A criminal charge in law brought by the police and the prosecutor under the Criminal Damage Act for criminal damage, and this is what this act is about, criminal damage. It says that if you're using if you have or are using depending which one it is, because there are many different laws and rights, privileges and interests, but if there's one in use, a right, privilege or interest, which is going to be the rights, privileges and interests, rights and privileges, they are recognised in the criminal procedure rules, which all this has to follow under the overriding objectives 1.2 D and HIV, which is recognising the needs of other cases or other causes and recognising the rights of the defendant. Any case brought under the criminal procedure rules for any offence, any act, has to recognise the rights of the defendant, right? Recognise them. They don't have to prove them. They don't have to prove them beyond reasonable doubt in front of a jury in a court. They only have to be recognised by the court. All parties, every party. That means the prosecutor, the police, the court staff, the judge, the claimant, but it's not the burden solely of the claimant. It's equal burden and responsibility of every party under those rules. All parties, where they're evident, particularly if they're being advertised in a political action, right? So, when they bring in this criminal damage charge, right, it says that it will not be misconstrued, it won't be mistaken, it won't be misunderstood as a defense, right? A defense, that's if you're pleading not guilty, right, and defending it. It won't be misconstrued, misunderstood, incorrectly. It will not be regarded or considered misconstrued as a defense against the charge, of which the charge has to be proved beyond reasonable doubt to a court of law in front of a jury in proceedings. It won't be misconstrued as that. If you are recognizing, if the court is recognizing a right, privilege, or interest, okay, it will not be misunderstood as a legal defense with evidence which needs to be proved to a jury in a court, right? It will be recognized only under the criminal procedure rules, okay? So what are these rights and privilege and interests? Okay, well, it starts with Magna Carta and the right of to bring a case with the oath and consent of your peers. And then we get this 1688 Bill of Rights, right to petition, that is the right of the subjects to petition the king and all prosecutions and commitments for doing so are illegal. All prosecutions. So you can't be prosecuted. It's illegal to be prosecuted. So this here, it's not to be construed as a defence against a charge, because you're recognising a right. You'll not be prosecuted. Okay? How can we be confident that that is true? And it would apply to a political promo that might have caused damage or committed an offence like criminal damage. Well, in the 1689 Claim of Right Act, which was just done just after this one, it clarifies that you're not to be imprisoned for petitioning. And it also clarifies, though, that you can be liable to civil action, civil case against you instead, because the 1688 Bill of Rights says that we're not to be prosecuted criminally. We're not criminally liable under that right, privilege, or interest. So it's not to be construed as a defence against a charge when you're recognising the right and the overriding objectives, which you don't have to prove the right beyond reasonable doubt. It has to be recognised. It's not proved with evidence to a jury beyond reasonable doubt. A defence against a charge is proved to a jury beyond reasonable doubt. And just to make sure that these definitely are, I can convince you even more of these, because in the book that Parliament uses, which is Sir Thomas Erskine May, The Usage of Parliament, Sir Thomas Erskine May, Usage of Parliament book. Parliament use this book. It's their go-to book for parliamentary procedure. They publish it on their website. In the first edition, there's a section on petitioning Parliament, and that will be from page 300 to 308. And it says that as long as you're not lying or committing fraud, that you're doing what you say you're doing, that all the petition activities are come under privileges of Parliament, right? When you're seeking matters of state, church, or law. And to further, just to make sure that the activities that these Phoebe Plummer and Anna Holland were doing, just to be certain that, you know, some people might say, well, they haven't got a petition and they weren't collecting signatures for a petition, and names. Well, Just Stop Oil have got they've got requests and demands to Parliament through their campaign. Now, this is where we look at the 1661 tumultuous petitioning act. The 1661 tumultuous petitioning act, which is Public Act 13, Charles I. That's the act that William Penn and William Mead were prosecuted under for getting large numbers of people in the street. They were accused of petitioning in the street merely by the verbal consent or other consent other than by hand to a cause of church, right? No one signed any paper. They consented by other consent, as in like nod or wave or all say aye or whatever, right? And this covers remonstrations in public over matters of church or state or law, right? So either have Houses of Parliament or the King. So this, that sets out what we're talking about under petitioning, which is, I wrote a paper called The Requisitions of Petitioning. I didn't know about this act at the time, but this helps to clarify. That's been repealed now. There is no, you used to have to get consent through Court of Civil Requests for permission from 3 justices or a jury to get more than 20 people engaging in the petitioning, right? So it's absolutely unequivocal. In fact, the Criminal Damage Act, the model for it is actually, it's so perfectly fitting for it that I don't know. I knew when I read that Act 2000, well, I was studying it 2019 for my case, and I understood it straight away. I didn't know about the Tumultuous Petitioning Act or the Claim of Right. I knew about the Bill of Rights. I didn't know about Thomas Erskine May. These, I knew the model. I knew what the model was, and I knew what the laws, but for some reason, justices don't believe you. They say you're talking poppycock or tosh. They don't know the law, or they're in contempt of the law. Either they don't know the law and they need to learn it, or they're in contempt and they don't like or believe in it. And this is what we find in the tumultuous petition in the William Penn, William Mead case. We've got justice, recorder, aldermen who don't think that these people deserve rights or should have them. The irony in the William Penn case is that the jury said that they weren't doing a petition campaign. Therefore, they couldn't have been doing a petition without authorization because they weren't doing petitioning, the jury said. They were just in the street talking to people. That's the irony in it. And the irony is, if they were petitioning, they would have protections and immunities under the Magna Carta, but by the consent of all the people in the street, right? because it would make it into an official petition. But because it was a large number of people in the street without authorization from a court, then it's a petitioning with immunity which had an offence because they didn't get permission to go so big. But now there's no requirement to. And I think Priti Patel thinks that you can be prosecuted for petition, or she could just make a law. Oh, we'll get some laws shoved through straight away. Well, when you're using a privilege which they can't stop you from using, and if you've got a right to use, that unequivocally and undeniably, actually, you're not on the defence track against a criminal charge, you'll have a job getting prosecuted under any act of law, particularly the Public Order Act or Town and Country Planning, particularly when it's not even criminal damage, when it's like, defacement, which you're exempted from, not to be regarded as incorporated into the fabric of the building. So it's quite clear. But the thing is, we're not getting anything done about this. Well, some cases we seem to be getting some progress, not really in the Extinction Rebellion or Just Stop Oil cases. Because luckily for me, the fact is that because there is criminal procedure rules that has to be followed by all solicitors from both sides, and the solicitors working in the court as well, possibly even duty solicitor, but whatever. Because of the criminal procedure rules, if you don't recognise the rights of the defendant, which is required, and if you're advertising Just Stop Oil campaign, and part of the point in doing the action is advertising the campaign, you're advertising, that you're advertising the rights that you're using. You're advertising you're using rights. So because these have not been complied with, the criminal procedure rules, it's a breach of procedure rules. So the Solicitors Regulation Authority, if solicitors are in a breach of the rules, then the Solicitors Regulation Authority actually has to enforce the rules or step in or take action. And that's where I am with it now. And some people have said in the past they've tried to claim, we don't regulate the Crown Prosecution Service. When you read the Crown Prosecution Service website, it says that we have solicitors working within the Crown Prosecution Service who are SRA regulated. Okay, the Crown Prosecution Service is not regulated by the SRA, Solicitors Regulation Authority, but solicitors working at the CPS are regulated by the SRA, and they have to comply with the SRA rules, or the SRA can enforce them. And you're meant to inform the SRA, Solicitors Regulation Authority, as soon as practically possible if you're aware of a breach. In most cases, immediately. So that's how I'm going with it now, because I've tried to complain to the court through the normal procedure. Christopher Hare, the judge, seems quite adamant to try and ignore. I've complained to judicial conduct. I've had some success with some cases to judicial conduct, but because I've been submitting a high number of cases, they've kind of got annoyed with me because I've been submitting a lot of cases. So I've had quite a few investigated. I've had some success. So, but this time I'm getting sick of it. I've actually represented directly to the Crown Prosecution Service. I think that we might have got some intervention with one of the ULEZ cases, Nick Harlot's. I haven't had it 100% confirmed yet, but now the CPS is saying they don't have a case against Arlett. So what can you say? Are the police prosecuting themselves? Well, not are the police prosecuting themselves, but are the police prosecuting Arlett, not the CPS? We don't know. No one seems to know what's exactly going on at the moment. They're being elusive. So I can take it to the Solicitors Regulation Authority. There is a line of pursuit with them. They are responsible for making sure all the solicitors do not breach the rules of conduct, which includes the criminal procedure rules. It is a valid line of inquiry. What else can you do? They are meant to be like this. The reason they're there is for if things aren't being done properly. So who can you go to? It's like being at school and you're getting bullied and you got the headmaster if you didn't do anything about it. They're there so that the rules are followed, right? I'm not wrong about this, and I'm not wrong about the fact that you can complain to them about this. So they are they're like not the last resort, but they're the rules aren't being followed. What else can you say? The rules aren't being followed, and they're there to enforce the rules and make sure they're complied with. And if they don't, then God help us. What are they there for? That's the point. I think that's the point. But this all fits now, and as far as I'm concerned, Priti Patel can stick her Public Order Act 2023, where she wants. But she can lock it onto her pension book for all I care. And I almost forgot as well. Let's not forget this. So, the particular two defendants who I'm talking about, which is Phoebe Plummer and Anna Holland of Just Stop Oil. So apparently their trial's been on this week. I don't know if it was Monday, Tuesday, Wednesday, Thursday, or what. I don't know if it's Tuesday, Wednesday, Thursday, or Monday, Tuesday, Wednesday, Thursday, but they weren't in today looking at the Crown Court list. They're not in today, which is Friday. And they didn't get sentenced the final day. They've got sent away. They've got 2 months before sentencing. I never got 2 months. I was straight in there, in one morning, and it was like the most mock of a mock trial you can have, with a cheap car salesman, Crown Prosecutor. He could have sold them a box of matchsticks, for £1 million, that Crown Prosecutor, So they've been convicted by a jury in a court. They've been convicted in a jury by a court, yet they were using a right that was failed to have been recognised, and it hadn't to. The recognition of that right under the criminal procedure rules, which is required, is not to be construed again as a defence against a criminal charge. So you don't have to prove it to a court of law in front of a jury because it ain't to be misconstrued as a defence, right? It's recognised, not proved beyond reasonable doubt. And so they've been convicted by this jury due to a breach of the procedure rules. Now, the thing is that the right, which is this 1688 Bill of Rights, right to petition under parliamentary privilege, okay, this is now an unlawful act because they failed to have their rights recognised when prosecutions are illegal. So now their current status is they are victims. They are now victims, right? So, of this act, they're victims of this prosecution against them now. So, in the Human Rights Act 1998, okay, we've got section 6 and 7, acts by public authorities. So Parliament an act by a public authority can be the police or local council or a court, because it's a public authority, but not anything that is done in connection with Parliament. That is not the act of a public authority, which is your petitions to Parliament, okay? They're separate. Now in 7, so an act of a public authority would be a prosecution through the court, right? Or police prosecution. That's an act of a public authority, but not something done in connection with Parliament, because that's why you're not supposed to be prosecuted by the authority, because it's under the authority of Parliament and jurisdiction, right? So your Human Rights Act 1998, Section 7, 1B says that a right, which is these rights that we're using here, can be relied upon. You can rely on it, use it, which means that it can be recognised under the criminal procedure rules, okay? Not to be construed as a defence against a charge. Well, if you're in any proceedings, any proceedings, civil or criminal, so we've got the sentencing proceedings that are now July or September, right? The sentencing proceedings are in September. They've been set in 2 months, right? Those are proceedings, right? The right can be relied upon under the criminal procedure rules as a requirement to be recognised under the criminal procedure rules, not to be construed against as, not to be misunderstood as a defence against a criminal charge, because you're recognising a right. It can be recognised, relied on in any proceedings, including sentencing, okay? As long as only if you'll be a victim, right, of the act. So because they've been prosecuted illegally and their right has not been recognised under the overriding objectives, because they ended up defending a criminal charge when they shouldn't have done, they are a victim. They are victims. Therefore, they've got the right they have a legal right for it to be recognised even in the sentencing proceedings under the Human Rights Act 1998, Section 7, 1B. Okay? So that's where I am with the Solicitors Regulation Authority. So for this Phoebe Plummer and Anne Holland case, someone in the Crown Prosecution Service solicitors has got some answering to do. Possibly even solicitors working at the court as well. I don't know whether the clerks are regarded as regulated solicitors or not. I'm not sure, but possibly police solicitors, King's Counsel working in the police, things like people like that. Patrick Gibbs KC, possibly Patrick Gibbs KC when he's representing the CPS, Lord Hanningfield. So that's where I am with this. This is clarified. This is a sketch, so you can visually see. It's all, the Criminal Damage Act's a perfect example for it, really, and the Town and Country Planning Act. The majority of Just Stop Oil is defacement anyway, and usually only a fine, but they're exempt from it. The Criminal Damage Act is the one the police don't like, because they throw Criminal Damage Act to anything, but it's actually made for this, funnily enough. It's so tailor-made for this that, even the driving, you see, in the Road Traffic Regulation Act and the early Road Traffic Acts, you see, even for some driving offences, I'm going to throw this in now because this affects me in my case. I might as well, now I've explained the whole model. the CPS and the police will want to see something in the act that they're bringing the charge under, yet overriding objectives through any case under the criminal procedure rules anyway. But so in the first act that had like dangerous driving and so forth in, it had special reasons. It had special reasons not to convict. So if you can have a special reason, then surely, if you can have a special reason not to convict, then surely if you were using a privilege, right, or interest under a special act of law, then that would be a special reason. So you can have it. Now, the ironic thing is that they removed the special reason from the dangerous driving clause. And I didn't find the older acts when I could have done with knowing that. But they do have it now under the red light offence for failing to stop at a traffic light. You can have special reasons. They've put it on for traffic lights now, okay? I don't think they have it on speeding. Police, fire and ambulance have got their own, you know, if it would hinder the vehicle for the purpose of, if it would hinder the progress of the vehicle for the purpose of which it is being used, the speed limit doesn't have to be observed. So you don't have to actually observe a speed limit. That means that there is no speed limit for if it would otherwise hinder the vehicle. No one challenges on them on that. You could probably, you know, if you wanted to with a private prosecutor, you could challenge every single, you know, you could challenge them all day with it if you wanted to. You might get some of them convicted that you know, although it's almost meant to be written like the Riddler, you know, it's almost a riddle. Now, the thing with, so there used to be special reasons on dangerous driving. The thing is, you don't really need it anymore because they've got the, well, actually, I think is it the Criminal Damage Act? I think it's the Criminal Damage Act. I think it's because if you're dangerous driving, you might cause damage or you might be a risk of putting people or property at risk of being damaged. But it says that, you know, if you're using the right privilege or interest, it's not construed against defence against a charge. When it's to do, they've got a section on it for elements of danger when you're a risk or at danger. It's only dangerous driving if there is a risk of danger or elements of danger to the public, right? And without the danger in effect, it can't be dangerous. And if you're using the right privilege of interest, which removes the liability for danger or putting the public at risk or danger, you're never at liability of putting the public at risk or danger. So you can't be in a dangerous situation of liability. They use that for the fire. A good example for that is putting a fire out, you know, because you might need to, firemen might have to spray foam over other vehicles or over other buildings that might get damaged while they're putting a fire out on another building. So they're not criminally liable, and it's usually insured. So, you know, there's one other thing as well about that. The very first special reason, the very first special reasons for dangerous driving that's been removed. Now, there's something that I read in the Edward Fitzgerald book, Smoke and Mirrors. So the Edward Fitzgerald book, Smoke and Mirrors, which is mostly about Magna Carta and the origins of petitioning rights. Now, Edward Fitzgerald says in that book, and I've got it over there, I could go and get it. I mean, it's just over there on a pile of books. I'm looking over towards it now. I could bring it over here and spread it open and put this pen on the writing. But I'll just tell you now, it says that there's a legal principle in law that you can rely on or use repealed law that's been repealed, but only as a defence. So that means that if a law's been repealed and something is no longer a crime, you can't prosecute anybody with it or bring a civil claim through it because that law's been repealed. But it can be used in defence or as a defence. the basis, the principle of it can be used as a defence or as part of a defence. Now, I would say that you could, therefore, when it comes to dangerous driving, can you have a special reason? Well, you used to be able to. So it's not out of the question. It's not like it never did have the potential to use special reason, which means that you used to be able to have rights, privilege, and interests in effect. But the thing is, if you have a right, privilege, and interest in effect, you're not defending the charge, and you don't have to prove that beyond reasonable doubt. You only have to have it recognised, and it's recognised through the criminal procedure rules overriding objectives, which is why it's not really supposed to be part of a defence or a defence, something that has to be proved to a jury, only something that has to be understood and recognised. And this is what this whole video is about, trying to get you to understand it and recognise it. Education. And this is what they do, in the court on other rights, like medical rights of staff, or where's the fire escape, when the fire alarm rings, it's education. You don't have to prove to the jury that, everyone needs to go out of the fire door if the alarm rings, So that's where I am with it. It's with the Solicitor Regulation Authority, as far as I'm concerned. If they're not going to act, then who is going to act? They're not defending the Solicitors Regulation Authority in this breach of procedure rules. Failure to recognise a right is not to be construed as a defence against a charge. So they're not actually defending Plummer or Holland. And I'm not asking them to. I'm asking them to make sure these rights are recognised and the overriding objectives are applied properly, when I think that everyone's aware that these rights are in effect in use. Mainly that Plummer and Holland, the very act they were doing was promoting their cause and campaign. So the point of the actions of Plummer and Holland were to advertise and promote their political campaign.